Jamie Raskin didn't walk into that hearing looking for a polite exchange. He walked in with one goal: to force an answer that nobody in that room seemed ready to give. And within seconds, the entire thing spiraled into one of the most chaotic and revealing confrontations we've seen in a long time. Because at the center of it all was a question that sounds simple on the surface, but gets a whole lot more complicated the moment you really think about it. How can a sitting president sue the federal government for $10 billion and then potentially benefit from a settlement controlled by his own administration?
And thank you, Mr. Chairman. I want to start by saying I appreciate what you said, Attorney General Bondi, and you said it to me personally, that you take the personal security of every member of Congress seriously and that people can contact you about that. And in these times, that's a very serious matter. So I thank you for that. Article 2, Section 1, Clause 7 of the Constitution is the Domestic Emoluments Clause. And it says that the president is limited to his salary in office and cannot receive any other money from the federal government while he's in office. It cannot be increased by $1. This president is the first president in U.S. history who has repeatedly sued the federal government for $230 million for the judicial search warrant at Mar-a-Lago, which was perfectly lawful and was never struck down. But now he's suing the IRS for $10 billion. He's suing the IRS for $10 billion, which I think is around 80% of its annual budget, because his tax returns were leaked. And they were illegally leaked by a private contractor who actually is in prison now, Charles Littlejohn. But he wants $10 billion. Now, I want to ask you the question of whether you think it would violate the Domestic Emoluments Clause for you to settle that $10 billion case or any of the other claims that the president has made against the government. He himself has remarked, it's interesting because I'm the one that makes the deal, right? And he says, I kind of have to work it out with myself. Do you think it would violate the Domestic Emoluments Clause for the president to work out a deal from people who are his subordinates under his unitary executive theory to get money in one of these cases?
I'm not going to discuss pending litigation.
Okay, so theoretically you're saying because his privacy rights were violated in that tax case, and they were. I'm with the president on that. I mean, his Mar-a-Lago thing is ridiculous, but there's no doubt that his tax returns, despite the fact that he promised to release them, despite the fact that every other president released the tax returns, he suffered embarrassment when it showed that he hadn't paid taxes for several years, and he had a right for that not to happen. Now, I want to turn back to the Epstein survivors, because President Trump may have been a little bit embarrassed by the release of those tax returns. How much do you think the claims of these survivors are worth? As the good congressman from Kentucky just pointed out, there were lots of survivors who had decided, for reasons of their own, never to release their names. That determination was represented to people in Congress, and we built it into our federal law that their names could not be released, and yet you published their names, their phone numbers, their addresses, personally identifying information. If Donald Trump can get $10 billion theoretically from the Department of Justice, how much should these people get for a far worse violation of their privacy rights and a far greater danger established to them in their lives?
Do you even know who Chase Mulligan is? You're so obsessed with, you don't, do you?
I'm going to teach you the rules again. You're the Attorney General of the United States. We have rules here.
You're obsessed with him.
You're the Attorney General of the United States.
You're obsessed with Donald Trump. You have Trump derangement syndrome.
Mr. Chairman, I'd like my time restored.
I'd like my time restored. In your district. In your district, and you don't even know about it, about keeping children safe from online predators.
Time belongs to the gentleman from Maryland. The gentleman can proceed.
Yeah, and I want the whole country to look at this, because this is the Attorney General of the United States whose job is law enforcement. We've never had a witness who has misunderstood our rules and been unable to conform his or her conduct to our rules before. We have only 5 minutes, and so we use our time to ask you specific questions.
How long are you giving me to answer?
Excuse me, I'm not yielding to you right now. I'd like that second restored too. So, Ms. Bondi, the way it works is we ask you a question and you answer it. And if you go off on a wild goose chase, another tangent, you start reading statistics, or you start talking about stuff going on in our district. And by the way, I invite you to my district. Come to my district, but that's not what we're here to do today. Okay? So, and you do that, then we're allowed to say we reclaim our time. At that point, you have to be quiet. You have no choice. You have to be quiet. So I hope you understand the rule at this point. Now, here's what I want to ask you. You're in law enforcement. We've seen all kinds of evidence of crimes. And when we go over to the Department of Justice for the 4 computers for every member of Congress, we see more evidence of crimes. Will you create a joint task force of the Department of Justice and governors and state attorney generals and district attorneys across the country to investigate the crimes that have taken place against these victims and more than 1,000 like them? The DOJ is not doing its job. Will you create a task force with state and local law enforcement to make that happen?
Gentlelady can respond if she wants to.
Thank you, Chairman. He called Chase Mulligan a wild goose chase and didn't even know who he was. He is a defendant in your own district who preyed on girls.
Mr. Chairman.
Well, you know what? If he were part of the Epstein investigation, you wouldn't do anything about it.
Online chat rooms and committed sextortion. Yet he didn't even know in your tiny little district who he was.
Mr. Chairman, she's embarrassing you.
He's about to be
This is your committee, and she is embarrassing
Shame
you.
on you.
The time of the gentleman has expired. I would remind the committee that last Congress, Secretary Mayorkas was here numerous times, and he wouldn't answer our questions, even when we sent them to him ahead of time in writing. So that's what we've had to deal with. I think the Attorney General is doing just fine. We have votes shortly. I will go to the gentleman from Virginia.
That's not just awkward. That's a legal and ethical storm waiting to explode. And the moment Raskin brought it up, you could feel the tension shift. This wasn't just another routine hearing. This was different. Because this wasn't about speculation or rumors. This was about a real lawsuit, real money, and a very real possibility that the system might be forced to answer a question it has never had to answer before. And when Pam Bondi was asked directly about it, instead of a clear explanation, what followed was hesitation, deflection, and a response that only made things more confusing. Now here's where things start to get serious. The lawsuit itself is massive. We're talking about $10 billion. Not millions. Not hundreds of millions. $10 billion. The claim centers around leaked tax returns, which were allegedly exposed by someone who didn't have the legal right to release them. And to be fair, there's an argument there. Privacy violations are real. Leaks like that can have consequences. But the scale of this lawsuit is what raised eyebrows across the board. Because even if the claim has merit, the amount being demanded is so large that it forces people to ask a bigger question. Is this about justice or something else entirely? And here's where the situation gets even more complicated. The Department of Justice, the same branch of government that ultimately represents the federal government in legal matters, is also part of the executive branch. The same branch the president controls. So if a settlement were ever to be discussed, negotiated, or approved, it would involve people who are technically subordinate to the very person bringing the lawsuit. That's not just unusual. That's unprecedented. Raskin didn't dance around it. He went straight to the point. He referenced the Constitution, specifically the clause that limits what a president can receive while in office. The idea is simple. A president is paid a fixed salary, and that's it. No bonuses. No extra payments. No side deals. The purpose is to prevent exactly this kind of situation where personal financial interests could overlap with official power. And so the question he asked was direct and impossible to ignore. If a president is suing the government and stands to gain financially from that lawsuit, does that violate the Constitution? But instead of a clear yes or no, the answer shifted. The focus moved away from the core issue. It became about not discussing pending litigation. And while that might sound reasonable at first, it didn't sit well in that moment. Because this wasn't about the details of the case. This was about the principle behind it. And when that principle wasn't addressed, it left a vacuum. And in a hearing like this, a vacuum doesn't stay empty for long. It gets filled with frustration, tension, and eventually, confrontation. But that's exactly what happened next. Raskin pushed back. He made it clear that the question wasn't going away. And when the answers kept drifting off topic, the tone of the entire exchange changed. Suddenly, it wasn't just a legal discussion anymore. It became a battle over control of the conversation. Who gets to speak? Who gets to interrupt? Who gets to decide what gets answered and what doesn't? At one point, the frustration boiled over completely. Raskin had to explain the basic rules of the hearing. The idea that when time is reclaimed, the witness has to stop talking. That might sound like a small procedural detail, but in that moment, it carried a lot more weight, because it showed just how far things had drifted from a normal exchange. This wasn't structured anymore. This was chaotic, and just when it seemed like the conversation couldn't get more intense, Raskin made a move that shifted everything again. He pivoted, away from the lawsuit, away from the money, and straight into something far more personal and far more emotional. The Epstein survivors. This is where the tone changed completely. Because now we weren't talking about billion-dollar lawsuits or constitutional clauses. We were talking about real people. People who had already gone through unimaginable situations and were now facing something new. Exposure. Not metaphorical exposure. Literal exposure. Names, addresses, personal information, details that were supposed to be protected, and according to multiple reports, those protections failed. Documents were released with redactions that either weren't done properly or weren't done at all. In some cases, information that should have been completely hidden was visible. And once that kind of information is out there, there's no pulling it back. It spreads. It gets copied. It gets archived. It becomes permanent. That's why this part hit so hard. Because while one side of the conversation was about a potential $10 billion payout for a privacy violation, the other side was about victims who couldn't even get basic privacy protections in the first place. That contrast didn't need to be explained. It spoke for itself, and the details only made it worse. One attorney representing survivors said that one of their clients was identified hundreds of times in the released documents. Hundreds. Not once. Not twice. Over and over again. And even after being notified, it took time to correct. Time during which that information was already out there. Experts pointed out something else that added another layer to the situation. Redacting sensitive information is not new. It's not experimental. It's something that's done regularly in cases involving vulnerable individuals. There are established procedures, clear guidelines, systems designed specifically to prevent exactly this kind of mistake, which led to an uncomfortable question. If those systems exist, how did this happen? Some people say it was incompetence. Others suggest it might be something more complicated. But regardless of the cause, the result is the same. People who were supposed to be protected were exposed. And for some of them, the consequences were immediate. Reports of threats, harassment, fear that something worse could follow. And that brings everything back to the central conflict of the entire hearing. On one side, a powerful figure pursuing a massive financial claim for a privacy violation. On the other, individuals dealing with the fallout of a privacy failure that directly affected their safety. The imbalance there is hard to ignore. Raskin didn't ignore it. He leaned into it. He asked a question that cut through all the legal language and went straight to the heart of the issue. If one person can potentially receive billions for a violation, what are these victims entitled to? Not just financially, but in terms of protection, accountability, and acknowledgement. That question didn't get a clear answer either. And by that point, the pattern was obvious. Direct questions leading to indirect responses. Serious concerns met with deflection. And each time it happened, it added more fuel to the fire. By the time the exchange ended, the room wasn't calm. It wasn't resolved. It was tense. Because nothing had really been settled. The questions were still there. The concerns were still there. And the implications of everything that had been discussed were still hanging in the air. And that's what makes this moment so important. Not because of who raised their voice or who interrupted who, but because of what it revealed. A system being pushed to address something it isn't fully prepared to handle. A conflict between power and accountability. Between procedure and reality. Because at the end of the day, this isn't just about one lawsuit or one hearing. It's about how situations like this are handled moving forward. It's about whether the rules apply equally or differently depending on who's involved. And it's about whether the people who are supposed to be protected actually are. And that's the part that sticks with you after everything else fades. Not the shouting, not the interruptions, but the unanswered questions. The ones that don't go away just because the hearing ended. The ones that will keep coming back until someone finally addresses them directly. So now it turns to the public. To the people watching moments like this and trying to make sense of them. Because ultimately, The pressure for answers doesn't just come from inside those rooms. It comes from outside too. From people who want to know how this works and why it works that way. If you made it this far, you already know this wasn't just another routine exchange. This was something bigger. Something that raises questions that go far beyond one moment in one hearing. And whether those questions ever get fully answered is something we're all going to be watching closely. Make sure to like the video, subscribe to the channel, and turn on notifications so you don't miss the next breakdown. Because stories like this don't end in one clip, and we're going to keep following every development right here on the channel.